My dear friends, I am taking 10th question of paper K 5001. And what is the 10th question? Describe the power of an appellate court. Can additional evidence be allowed during appeal? This is the question. Now answer. Power of appellate court. Under section 107 and rule 23 to 29 and 33 of order 41 provide that the powers of appellate court while hearing first appeal, these powers may be summarized as under. My dear friends, under these sections, the powers of appellate court are as under. First power, to determine a case finally. Section 1071A and Rule of Order 41 enable the appellate court to dispose of a case finally where the evidence on record is sufficient to enable the appellate court to pronounce the judgment. It may finally determine the case in spite of that judgment of the trial court has proceeded wholly upon some ground other than that on which the appellate court proceeds. This is the first part. This is the first power which is given by the under this section 107 and order 23 to 29 and 33. And the general rule of this first power is my dear friends, as I have said, the general rule is that in the first power, the general rule is that a case should, as far as possible, be disposed of on the evidence on record and should not be remanded for fresh evidence except in rare cases. It means the evidence will be the same and will not be changed. This is according to the first power given to the trial court by the appellate court. Now, second power, to remand a case to the trial court. This is the second power. Remand means to send back. What is the meaning of remand? Remand means to send back. What send back? Case can be sent back where the trial court has decided the suit on a preliminary point without recording finding on other issues. And if the appellate court reverses the decree so passed, it may send back the case to the trial court to decide other issues and determine the suit. This is called remand. By passing an order of remand, an appellate court directs the lower court to reopen and retry the case, and trial court will re-enter the case, and the number will be same allotted to the same number will be allotted to the case to proceed the case as directed by the appellate court. When the case is sent back to the trial court, the number of the case will remain same and case will again be registered by the trial court to proceed to further proceeding on the case. So this is the second power that is to remand a case to the trial court. Now I am taking third power. Now I am taking the third power given to the appellate court by the section to frame issues and refer them for trial. Where the lower court has omitted, see here, where the lower court has omitted first to frame an issue or to try any issue or to determine any question of fact which is essential to the right decision of the suit upon the merits. It should be, it means according to this power, the case must be decided upon the merit. The appellate court may frame issues and refer them for trial to the lower court and shall direct that court to take the additional evidence required. The lower court shall try such issues and shall return the evidence and finding within the fixed time by the appellate court. Here I wanted to say that when the lower court has evidence and findings after returning the case by the appellate court, the lower court within the time fixed by the appellate court have to send the case back to the appellate court. The appellate court thereafter should hear the whole appeal, and the hearing should not be confined to the points on which the findings were called for under section 107 1C rule 25 and 6. My dear friend, this is the third power of the appellate court to frame issues and refer them for trial. If anything has been left by the trial court, the appellate court may direct to the lower court to do these things in a proper manner, and after doing, send the case back to the appellate court, and then the appellate court will hear the appeal again under this section 1071C. Now I am taking fourth power. My dear friend, fourth power of appellate court given by the section 107 to order to take additional evidence. As a general rule, the appellate court shall decide an appeal on the evidence led by the parties before the trial court and should not admit additional evidence for the purpose of disposal of an appeal. This is the condition. Under subsection rule 1 of the order 27 also. Thus, the parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. So the parties are also not allowed to give additional evidence. Now third, section 1071D, however, empowers an appellate court to take additional evidence or require such evidence to be taken subject to the conditions laid down rule 27 of order 41. Under this condition, appellate court can take additional evidence. So, my dear friend, this is the fourth condition, fourth power of the appellate court, which the appellate court can use in the decision of the appeal. Now I am taking fifth power. My dear friends, fifth power of appellate court to modify degree. Rule 33 of Order 41 empowers an appellate court to make whatever order it thinks fit, not only as between the appellant and the respondent. Here you see here, not only between the appellant and the respondent, but also as between the respondent and respondent. This is the power given to the appellate court. It empowers an appellate court not only to give or refuse relief to the appellant by allowing or dismissing the appeal, but also to give such other relief to any of the respondents as the case may require. This is the power given to the appellate court. This is the special power which can apply appellate court between the appellant and respondent between respondent, and relief to any of the respondent as the case may require. It can be given by the appellate court. Sixth power to execute all the functions as the court of original jurisdiction. My dear friend, sixth power to execute all the function as the courts of original jurisdiction. This is also a power of the appellate court. An appellate court can execute all the function of the courts of original jurisdiction. The appellate court is empowered to execute all the functions which the courts of original jurisdiction is entitled to do. This is the sixth power given to the appellate court. Now I will take seventh power, or the last power. My dear friends, the seventh power of appellate court to pass any decree and order. This is the seventh part. Seventh part, to pass any decree and order, or you can say the seventh power of the appellate court. Order 41 and Rule 33 says that under this power, what can appellate court do? Under Order 41 and Rule 33, the appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or made such further or other decree or order as the case may be required. And this power may be exercised by the court in spite of that appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties. Although such respondents or parties may not have filed any appeal or objection. My dear friends, this is the seventh power of appellate court. Under this power, an appellate court take any action which is given in this seventh description. So my dear friends, I think The 10th question, which I have discussed with you today, is clear to you. And in the last, I want to tell you, my dear friends, my channel name is Maths by Dharamveer Singh Dabas. And I want to make a request in the end. Please subscribe the channel and also like the channel. I shall be very thankful to you. Again, thanks.